Broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, ladies and gentlemen, and welcome to this IT governance webinar on the first steps towards GDPR compliance. My name is Alan Calder. I'm the Chief Executive of IT Governance, and I'll be your host today. My background is in information security, but before that in general business. I wrote a number of books around the management of information security, particularly in the context of compliance and data protection, going back some 15 or 20 years, and a number of those books have been published either by third parties or a couple of them internally by the publishing company, which was at the heart of what is now IT Governance Limited. IT Governance has grown to become a single source supplier of all of the books, tools, services, training, and so on that organizations might need in order to tackle their IT governance, cyber risk management, and privacy IT compliance requirements. And the knowledge which we've built up over the years serving organizations who have a wide range of requirements, from cyber resilience through data protection, cyber security, PCI, incident response, and so on, is what substantially informs this webinar this afternoon. We deliver those things through consultancy, through training courses, through books, publications, third-party products, through software tools, and through our technical services team. And all of that can be accessed through our websites wherever you are in the world. I'm going to be talking today for about 45 or 50 minutes about GDPR and GDPR compliance. At the end of that time, there'll be a Q&A session, so if you have questions, that's the time to raise them. I'll be happy to deal with them. If you have a question as I'm talking through the first steps towards GDPR compliance, then use the question function in the GoToWebinar control panel, which should be on your desktop. If you click on the right box, you can write questions into the box. When we come to the Q&A session, what I'll do is I'll read out the questions that come in the order they come in, so everybody knows what the question is, and then I'll answer it. So again, you all know what the answer to the question is. We're talking briefly about the regulatory landscape and the territorial scope of GDPR, what's now the Data Protection Act 2018 in the UK, the key principles that are incorporated in the Data Protection Act and the EU GDPR, breach notification rules, data subject rights, key changes in and around consent, which organizations need to be able to deal with, the liabilities on processes and through them on contractors, the role of the data protection officer, international data transfers, and then a brief look at regulators and pan-European consistency over what is intended to be a pan-European regulation. So for those of you who don't already know the difference, it's worthwhile briefly reminding ourselves of the difference between a directive and a regulation in the context of EU legislation. A directive is a directive from the European Commission to member state governments, telling them to pass laws that meet a minimum set of standards and that ensure a particular set of objectives are addressed. Individual member state parliaments will then create their own laws in the context of their own judicial framework, pass those into law, and they could implement substantially more than what the directive requires. The directive, in a very real sense, is a minimum set of requirements. A regulation, on the other hand, is a law. It goes into effect at the same point as written in every single member state. It's possible that regulations will provide some room for member states to adopt particular aspects to suit themselves, and these are called derogations in the context of GDPR. So they don't require any implementing legislation, although many countries will tend to pass an implementing law, not least because that's the mechanism for implementing the derogations. And the EU's General Data Protection Regulation is exactly as the name of it suggests, it's a regulation. So it became law, effective as law on the 25th of May 2018 by virtue of the European Union treaties and legal structure, irrespective of whether or not other countries adopted it into law. From a UK perspective, it was adopted into law. It became the Data Protection Act 2018, which was also where the UK identified which specific derogations it wanted to deal with, and it enacted those into law at the same time. So from a Brexit point of view, if, as and when Britain leaves the European Union, GDPR will continue to be part of British law because it has been made part of British law. So the provisions of GDPR in the form of the Data Protection Act will live on beyond whatever date Brexit may or may not occur. Looking at what a data protection model under the GDPR looks like, it starts with us, data subjects. We are living human beings. We own our data is the starting point for GDPR, and it recognizes that there are organizations who might collect and or process our data. The organization that collects our data is defined as a data controller because it determines the means and purposes of processing data. It might choose to outsource some of that processing to a third party, a data processor. So typically an organization employs staff, and it might outsource some of the payroll processing to a payroll organization, which would be a data processor. That's legally allowed, except the data processors are now clearly defined under GDPR, and there are specific obligations between controllers and processors. It's also possible for a data controller to move data to a third country. So you might, in the UK, be collecting data which you are moving for one reason or another. Perhaps it's a software provider or a head office in the United States. So you can move data to third countries, again, subject to very specific laws. You can also share data with third parties, and in fact, third parties can provide you with data about data subjects. If they do, you're obliged to ensure that data subjects know where you got the data from. So buying an email list is still legally practical and possible. You just have to make sure that you comply with law in terms of how you deal with that. So controllers have duties in respect of data subjects, and those duties reflect the rights of the data subjects. The Information Commissioner exists to ensure that data controllers behave consistently across the European Union. So they have a role in ensuring that enforcement is carried out consistently and correctly, that assessments are carried out in a way that is consistent and coherent, and that the level playing field which the regulation was designed to provide will actually be effective. And so we hear, for instance, from the European Data Protection Commissioner, the person who leads the Data Protection Board, that the first major fines under the GDPR will be made towards the end of this calendar year. There will be some coordination, it appears, between the 25 supervisory authorities who have so far between them identified some 88,000 data breaches since the 25th of May, and the initial enforcement actions, some of it already happened, but the main thrust of enforcement actions we will see apparently before the end of this calendar year. So the Information Commissioner, under the overall review of the European Data Protection Board, is the enforcement authority in the United Kingdom. And one of the key issues that all organizations have to make sure they're dealing with in relation to personal data is, of course, the security of that data. And I'll come back to that a couple of times in the course of today. So just looking at material and territorial scope of the regulation, it's clear that the GDPR applies to the data of natural persons. A data subject is a living individual, so deceased persons have no rights, although obviously those people administering the estates are still alive, so they do have rights. And the rights a natural person have are related to the protection of their personal data, the protection of the personal processing of that data, and the unrestricted movement of that data within the European Union. Any personal data that's processed wholly or partly by automated means is within scope, and if it's part of or intended to be part of a filing system, it's also in scope. So that means that data, both digital and analog, is captured by the regulation. Collecting business cards is collecting data that is potentially under the scope of GDPR, although if you don't put it into a filing system or don't intend to, it will be out of scope until such point as it becomes part of or is intended to be part of a filing system. The territorial scope obviously applies to organizations based in the European Union, so controllers and processors based in the European Union have to comply with GDPR. It also applies to controllers and processors who are based outside the European Union but are providing services into the European Union. And so that means that an American or an Indonesian or a Chinese organization which is selling services, whether by internet or some other means, specifically into the European Union, must also comply with GDPR. And this is why you will have seen a number of organizations around the world blockade their sites and say that if you're from the European Union, they won't give you access to the website because they've decided the cost of meeting GDPR compliance requirements is greater than they expect the benefit to be from providing services to you. So material and territorial scope, very important part of understanding how you're going to go about complying with the requirements of the GDPR. And it's important to understand that because compliance is now enforced in two particular ways. The first is that if you have a data breach, you have to report it. If there is something about which a data subject is unhappy, they have enhanced rights to bring a complaint. So that's one side of the challenge. The other side is that if you have a breach, you are potentially subject to regulatory action and or monetary penalties. Monetary penalties can go up to a maximum of 4% of global turnover, last year's global turnover, and that is, there is a tariff, so major breaches of GDPR, and those are to do with personal rights of data subjects, to deal with the data protection principles and with the export of data outside the European Union. Breaches there can attract up to 4%. Breaches anywhere else, the tariff sets out. So, for instance, failing to report a data breach, failing to comply with the instructions of the Information Commission, all of those can attract penalties of up to 2%. And the way penalties look as though they'll work is a bit similar to under the Data Protection Act at the moment, which is that you need to prove that you were not negligent in complying with your obligations, and the extent to which you can prove you're not negligent is the extent to which you can make sure the fine comes down to a level somewhere between can live with or doesn't exist. So thinking about the way in which you prove that you are not negligent is an important part of thinking about your strategy for GDPR compliance, because your requirement is that you apply appropriate technical and organizational measures to protect personal data, and the basis on which fines are levied has to take into account an assessment of how well you've done that. So while fines have to be proportionate, effective, and dissuasive, they have to take into account the extent to which you have gone about meeting your obligations under GDPR. Worthwhile understanding what a personal data breach is, as that's where your trouble starts. Failure to comply with GDPR will often be identified because there's been a breach which you either report or which is reported by somebody else. And a definition of a personal data breach is any breach of security leading to the accidental or unlawful destruction, loss, alteration, unauthorized disclosure of or access to personal data, however it's being transmitted or stored. So that's a very wide definition of a personal data breach. It means, for instance, that if an NHS trust hospital has a successful cyber attack on it, such as happened during the course of last year, the breach, which clearly breached confidentiality of data, it's claimed there was no impact on integrity of data, but it also affected availability of data such that many operations had to be cancelled. Those are significant aspects of a GDPR data breach, and you would expect to see fines levied accordingly. Where there's a data breach, there is an obligation on data processors and data controllers to notify. Where a controller's outsourced some of the processing to a processor, the processor under contract from the controller, and it's a requirement that processors operate under a contract, have to notify the controller within a given time period. And that time period is 72 hours or as quickly as possible, if less than 72 hours from the point at which the breach is discovered. That applies to breaches of any sort. Any type of breach has to be notified by the processor to the controller. Controllers have a little bit more latitude. Controllers, as soon as they become aware of a breach, their clock starts ticking, got 72 hours within which a breach has to be reported, or quicker if that is possible. And the breach has to be reported if there is a risk to the rights and freedoms of data subjects. If there is no risk to the rights and freedoms of data subjects, and this is a decision which is in the hands of the controller, then it's not necessary to report a breach to the Information Commissioner. If there is a high risk to the rights and freedoms of data subjects, then that breach has to be reported to the data subjects themselves. It's up to controllers to determine what the measures will be to identify what each of those risk levels look like: low risk, risk, and high risk. But typically from our own services, we provide data protection officer as a service to a growing number of organizations. We see round about 20% of all breaches reported to us are breaches which need to be reported to the Information Commissioner. We haven't yet seen one from our clients where there is also a need to report it to the data subjects themselves. And we think that's probably a reasonable perspective, or a reasonable perspective at the moment, on what the proportion of breaches looks like. The number of high-profile breaches with big impacts on large numbers of data subjects, like the BA breach or the Equifax breach, those are in proportion to the numbers of breaches where there is an impact on the rights and freedoms of a number of data subjects, or where there is none. Those are, in that context, relatively few. There are, as it happens, a lot of them, which will give you a sense of why, when the European Data Protection Board talks about 88,000 data breaches reported in the 5 months since the 25th of May, that's quite a significant number. So data controllers must notify the supervisory authority, and the failure to report within 72 hours has to be explained. You would expect that Yahoo, if it had a breach again and behaved as it did with the breach that happened back in 2013, which it took 3 years to discover and admit to, would find itself dealing with very, very substantial fines as a result, not only of the evident negligence in failing to spot that it had been breached, but in the period of time it took to report that breach. GDPR came into force back 2 years ago and has applied since the 25th of May 2018. There was a 2-year transition period from the 24th of May 2016, during which a growing number of organizations actually got to grips with, got on with preparing for GDPR compliance. The data suggests that currently somewhere between 25 and 30% of organizations are claiming to be GDPR compliant. Up to about a third haven't yet started on their compliance journey, and the number in the middle, which is somewhere around about 50% of organizations, are doing something around GDPR. And it's fairly commonly recognized that a number of organizations are just sitting waiting to see how big the fines come, not realizing that sitting waiting is a formula for being one of those organizations who's getting a fine because you've been breached and you weren't compliant. The approach of the ICO is very much to say, you have had 2 years to get compliant. There's been an awful lot of news about this in the press. You should be compliant. You shouldn't be trying to justify delays in compliance post 25th of May. So GDPR starts with the rights of data subjects, as I said, and so it's worthwhile just looking at what those rights are. The 11th article of GDPR says that the controller has to take appropriate measures to provide any information to the data subject about how their data is being used in a format which is concise, intelligible, easy to understand, easy to access, and clear and plain language. And given that if they ask about what you're doing with their data. That's how you have to respond. You should also think about when you're telling the data subject what you're planning to do with their data, you couch it in exactly the same way. So both how you respond when you're asked about data, but also in advance when you're collecting data, you should be very transparent and clear and intelligible in describing what you're going to do. You also have to facilitate the exercise of data subject rights. And facilitate means exactly that. It means you have to be clear with the data subject what their rights are, and you have to put in place mechanisms and processes that enable them to successfully implement those rights. And the rights start with the right to information to know what you're planning to do with their data. And that right can't be made conditional. It can't be bundled. You can't put 7 or 8 things you want to do with somebody's data together and say you have to accept all of them or none. You have to enable people to accept each of the different things individually without penalizing them because they choose not to agree that that's why you're going to deal with it. So right to information, right to access of the data that you're processing about them to find out whether you're doing what you said you would be doing, a right to rectification. If the data about them you're holding is incorrect or out of date, they're entitled to have you to correct it and for you to then correct it. The right of erasure, or what's called the right to be forgotten, is another right. That's not an absolute right. It applies under certain circumstances, and so when somebody wishes to exercise their right to erasure, you need to have a process which assesses whether or not it is applicable as a right under the circumstances where they've asked for it to be exercised. Where there's an argument going on, they have no right to object to processing if they think you're doing it wrongly or outside the provisions of the regulation. And if you're arguing over that objection, they have a right to restrict the processing of data until such time as the objection or the dispute over the processing is resolved. They have a right, again, it's a restricted right, but a right to data portability, to get back from you their data in a format which enables them to take it to another provider of similar services in the European Union. They also finally have a right to be informed of the existence of automated decision making, including profiling, and of the consequences to them of that profiling. So if you're for instance, assessing somebody's suitability for a mortgage, and that's an entirely automated process with an automated decision at the end, they're entitled to be told of that before you start the processing. There are 2 other, while those are the fundamental rights, there are 2 other related rights. The first, obviously, is that if they have consented to processing their data, they should have the right to withdraw consent. And where you're relying on consent, the data subject can withdraw consent and you have to stop processing at that point. Now, historically in the UK, many organizations have relied on consent for processing a wide range of data, and in reality that will not be a sensible way to continue, because there are better legal grounds for processing data than consent. But wherever consent is the basis and they withdraw consent, you're obliged to stop the processing immediately. They also obviously have a right to lodge a complaint with the supervisory authority, because it's the supervisory authority role to make sure that the way you are complying with GDPR is in fact compliant, and the supervisory authority's role is to make sure that the rights of data subjects are genuinely being protected. So starting point for GDPR is those 8 data subject rights, and you need to be thinking about them as you develop your GDPR compliant framework. The second area, major area in GDPR, as I said, there are 3 areas which occasion fines up to the 4% level: transgressions around data subject rights, transgressions around the 6 data processing principles, and transgressions in terms of transporter data processing. The 6 data principles are contained in the 5th article of GDPR. GDPR is a long document. It's got the first half of it substantially made up of what are called of a whole series of articles which explain the thinking behind specific aspects of GDPR, and then there are the articles of GDPR itself, and it's the articles which are the law. So Article 5 talks about the principles relating to the processing of personal data. These are often called the data processing principles or the data protection principles, and there are 6 of them. The first is that data should be processed lawfully, fairly, and in a transparent manner. Each of those words has a specific meaning and context. Lawfully means there has to be a legal basis for doing the processing, might be a contract, but whatever it is, it has to be a lawful processing. It has to be fair, so you have to be doing no more and no less than is necessary for you to achieve the lawful objective, and it has to be carried out transparently. In other words, the data subject is entitled to know what's going on, and they should be able to see through the means of a privacy notice, for instance, exactly what's happening. The second principle is that data should be collected for specified, explicit, and legitimate purposes. And those should be set out clearly in the privacy notice, which is provided to a data subject prior to the collection of their data. Specified, so you should be saying we're planning to use this data, A, in order to fill a contract with you, B, to send you further information about the fridge you've bought from us so that you can make sure it works properly, C, in order to help you renew your fridge warranty, and D, in order to introduce you to other fridge-related products. Each of those would be specified purposes. You need to be explicit about them. They need to understand that there is nothing you're going to do other than what you said, and each of those purposes needs to be legitimate. Legitimate purposes do include, under GDPR, direct marketing and security monitoring. You need to be clear that that's what you're going to do, but as long as marketing is being carried out to people who have inquired about a particular product or purchased a particular product, and it is likely that what you are doing is something that they might expect you to do in terms of providing them information about that, having carried out what is called a legitimate interest test, then what you're doing is going to be fine. I often think that it's the second principle. If you can make sure that you're complying with the second principle, actually it'll make it easy for you to comply with all 6 of them. If you're very clear about what you're collecting the data for, you've made sure it's specified, and you made sure you've got a legitimate reason for doing it, actually most of the rest of the principles will tend to be relatively easy to comply with. The data you collect must be adequate, relevant, and limited to what is necessary for that specified purpose. Must be accurate and, where necessary, kept up to date. So you don't need to keep data up to date unless it's necessary for the purpose for which you collected it. If it's no longer necessary, then of course you no longer have a reason for keeping it, and that's what the 5th principle is saying, retained only for as long as necessary. So arguably, data should always be up to date, because if you've still got it, then you've got a reason for keeping it because you still need it, therefore it should be up to date. Therefore, it makes sense to have a properly thought through retention policy which ensures that at the point where you no longer need data, you remove it completely from your system, and that removes the obligation to keep it up to date. It also obviously reduces the risks to the data and means that you have to spend less time and effort on protecting the data from a security point of view. And it's that 6th principle that is going to be the one that's going to get many organizations into trouble. It will be a breach of security around data that leads to an investigation which identifies that actually you're not applying the other principles, and fines are based not on the specific transgression but on the level of negligence which as consequent investigation identifies as being there. So you need to apply all 6 principles, and above all, says Article 5, you need to ensure that the controller needs to ensure that it's able to demonstrate compliance with those 6 principles. We think of this as being, in effect, a virtual 7th principle, the requirement that the organization recognizes that it should be accountable for the safe and compliant processing of personal data. And the ICO over a year ago, talked about accountability in the context of GDPR, and says it's quite clearly the requirement that boards and managements should put in place frameworks that will ensure there's a culture of privacy that pervades the entire organization. She said that GDPR evidently mandates organizations to put in place comprehensive but proportionate governance measures, in other words, a board-driven framework for ensuring that data is being correctly managed throughout the organization. And it should mean, she said, a change to the culture of the organization. You can't bolt compliance on afterwards. It needs to be built into part of the company's overall systems approach to how it manages and processes personal data. And for many organizations who got themselves into a reasonable state of compliance by the 25th of May, the work that comes on after that is about embedding data protection compliance in the organization, making sure that whenever you're reviewing a process, a DPIA becomes part of that review activity, that all of the data you collect becomes managed effectively, that your retention policy is effectively applied, that you're managing data subject access requests correctly. All of that should be ensuring that privacy becomes part of how you think about managing data inside the organization. And applying that principle of accountability really does mean starting at the board. Corporate risk register, a director with nominated responsibilities for ensuring GDPR compliance, very much like how we deal with health and safety at work. In a number of organizations, a data protection officer, there is a DPO required in organizations of certain types, but it's a practical appointment in many other organizations, particularly if you outsource the service, where you can buy everything that goes with having a DPO without having the headache of managing a DPO yourself. Developing a privacy compliance framework is the outward manifestation of how you're dealing with accountability. A combination of a personal information management system, BS 10012 is a standard for that, with an information security management system, and ISO 27001 is a way of doing that, gives you an externally verifiable framework that demonstrates you've done the best you can to comply with GDPR. You need to have records of processing. Article 30 requires you to identify what data you've got, where it is, how you're processing it, where it's stored. You typically use a data flow mapping tool in order to do that in any organization of complexity, because as you change processes, as you reorganize what you're doing, you need to be continually updating and managing that. One of the things you have to report on if you have a breach, remember in that 72-hour period, is what data has been affected. And the requirement of Article 30 is, one of the reasons it's there is to ensure that if there's a breach, you can very quickly identify where the breach occurred and what data has been affected. Cyber Essentials you should think of as a minimum security standard, but you should be thinking much more widely around certification as and when they occur. Data seals, ISO 27001 is the type of standard that GDPR allows to be used by organizations to demonstrate they're doing the best they can to meet its compliance requirements. What GDPR pushes for over time is organizations to move to data protection by design and by default. And the tariff of fines includes up to 2% for failing to meet the requirements around data protection by design and by default. So data flow audits, data protection impact assessments, which are mandatory for many organizations processing high volumes of special categories of data, for instance, are a good thing to be doing around any major system reorganization or significant changes to systems and processes. Article 6 then talks about lawfulness. Remember, mentioned lawfulness in the context of the first data protection principle. Lawful, the option is start with consent, but as I indicated, consent shouldn't be your default starting point. Consent there's a very high bar for. If somebody's going to consent, they have to be properly informed. You have to be able to evidence that they were properly informed. You have to be able to evidence that they genuinely consented. And that's quite tough. You've also got the challenge that they can then withdraw consent. So alternatives include processing in order to carry out a contract between you and the data subject. So if somebody buys something off a website, the basis of processing their personal data would be in order to fulfill the contract, which requires you to process payment and deliver something to them. You can process in order to protect yours or the data subject's vital interests, or in the legitimate interests of the controller. So in order to carry out direct marketing, that's a legitimate interest and therefore it's lawful. As I already said, controllers and processors are clearly distinguished in GDPR. Controllers responsible for ensuring that processes comply with the contractual terms for processing information. Processors should not be processing information other than with a contract from a controller. So if you're a processor, you need to make sure that you've got a contract in place for all the processing you're doing. Otherwise, you will by definition be a controller. So we touched on consent. Silence or inactivity does not constitute consent. Consent can be withdrawn at any time. And while that's all clearly understandable in relation to adults. It's more complex in relation to young people. GDPR says that under the age of 16, a young person cannot legally consent to the processing of their data for the purposes of an information society service unless the member state within which they reside has taken advantage of derogation which allows that to be lowered to 13 but no lower. The UK chose to lower it to 13. It means that young people 14, 15 years old can lawfully consent to the processing of their data by, for instance, Facebook or Snapchat, but under the age of 13, they cannot lawfully consent. And the onus is on the provider of that service to ensure that consent is being legitimately given. There's also under Article 9 a prohibition on the processing of special categories of data. That's what used to be called sensitive data. Special categories of data include race, ethnic origin, political beliefs, and so on. And you are prohibited from processing that, even if you think you've got a lawful basis for doing so under Article 6, and unless you can identify one of the exceptions listed in Article 9. And those include, we have explicit consent to the processing of this data for this specific purpose, or it's in the vital interest of the data subject. So blood group information might be in the vital interest of the data subject, for instance. But you need to think about that combination of Article 6, which talks about lawful basis, the legal basis in which you're processing data, Article 9, which prohibits the processing of certain types of data unless you can point out an exception to the prohibition. Articles 12 to 18 talk about transparency and processing. I mentioned that right at the beginning of the section talking about Articles 1 and 2. The processing must be clear, must be properly understood. You must provide information about yourself and the purposes of processing, information about their rights. And when somebody asks for information about what you're doing with their data, you've got 1 month to respond. You can't charge them for providing them that information. You can, if it's a complex matter, propose a cost which has to be reasonable, and you can ask to take longer than a month if it's very difficult processing. But typically, you've got to assume that you've got 1 month from the date at which you receive the request, and it doesn't have to be in writing the request to fulfill it. You do have to be sure the person making the request is entitled to, and there are specific provisions in GDPR which deals with how you deliver data, which might include data about third parties, just as there are requirements around how you tell a data subject that you got their data from a third party. So quite a complex area. Rights to access, rectification, erasure, and data portability all come into play when thinking about transparency and data subject access requests. So an area in which you're likely to want to have specialist legal advice or to be able to draw on specialist legal support when dealing with them. Articles 25 and thereafter deal with data protection. So in more detail, as we said, got to be built into processing by default. If you're not in the European Union, you have to appoint a representative inside the European Union. So for UK companies, the departure of Britain from the EU means that if you're providing services into the EU, you'll now have to have a representative inside the European Union who doesn't control what you do, but is the starting point for a data subject or information commissioner to deal with issues in relation to you. Touched on data protection impact assessments. They're mandatory for organizations who have technologies or processes that are likely to result in high risks to the rights and freedoms of data subjects and good practice elsewhere. A DPIA is the starting point for data protection by design. Data audits should become a standard part of the organization's ongoing compliance activity. GDPR specifically says that through the means of audits, managements can continue to demonstrate compliance with the requirements of GDPR. And audits can be carried out by your own trained team. You can hire data protection auditors to come and do the audit for you. There are a number of ways that you can tackle it. There are benefits of using outsiders because they'll be better at it than your own internal team. And what you're looking for in all cases is not just to tick the box of we had an audit, but actually we got an audit which identified things that we can do better. That all brings us back again to the security of personal data and the sixth principle, which says data has to be protected, and Article 32, which says the organization has to apply an appropriate level of data protection activity, organizational and technical measures to protect data, and to do that taking account of the risks that there might be to that data. There are no key tests yet as to what appropriate measures might be. There are emerging frameworks and standards, but it's up to the organization to determine, on the basis of a risk assessment, on the basis of the cost of dealing with the exposure, what an appropriate set of actions might be to protect the rights and freedoms of data subjects. GDPR points specifically at options like pseudonymization and encryption of personal data. Practical experience suggests that if you fail to encrypt data on USB sticks, on laptops, in databases, you expose yourself almost immediately to what's almost going to be an automatic fine. But on the other hand, encrypted data means that if there is a breach, you're actually not going to have to report it, because from a GDPR perspective at the moment, encryption means there's not going to be any risk to the rights and freedoms of data subjects. So deploy encryption, carry out regular GDPR audits, carry out regular testing, penetration testing, security testing of your network. Make sure that the measures you're taking comply with and enable you to demonstrate that you're complying with the idea of data protection by design. All of that comes together in the privacy compliance framework that I touched on earlier. The concepts of governance driven by a risk assessment and the need to comply with GDPR and potentially a greater range of regulations. The 6 data protection or privacy principles driving very specific activity around how you collect and process data, and then the detailed policies, procedures, controls, and records that you put in place to ensure that data is dealt with as you want it to be, and that you have evidence that it is so being dealt with. I said I would touch briefly on data protection officers, so let me do that now. GDPR says that in organizations processing substantial volumes of personal data, where that data is a special category of data, then they have to mandatorily appoint a data protection officer. A data protection officer is a protected position. You can't fire somebody because you don't like their advice, but the person has to be appropriately qualified and has to be consulted in respect to all data processing activities. Increasingly, we see small and medium businesses, even if they don't have the mandatory need to appoint a data protection officer, appointing one on an outsourced data protection officer as a service basis, as that's a cost-effective way of ensuring that you get really good, consistent, up-to-the-minute advice, practical advice on how to deal with issues that you are going to have coming across your data protection desk on a day-to-day basis. You also need to train staff widely through the organization, particularly those who are going to be responsible for dealing with data. HR, marketing, security people, IT people will need to understand what to do with data because they're building systems which process it. And general staff awareness training, for instance, how to deal with emails, what to do with the copy to function in an email, how to spot phishing emails. All of that should be part of the broader approach to making sure that not only do you have the right resources in the form of data protection officer, but you have appropriately trained resources through the organization. And from Article 40 onwards, GDPR talks a bit about how you can demonstrate compliance with the requirements to apply appropriate administrative, organizational controls and measures to protect the data of data subjects. GDPR is a law, so in reality, demonstrating that you're complying with the law is tough, because whether or not you're compliant is likely to be decided by a judge. And if you're following current developments, you'll see, for instance, that Morrisons, a large supermarket chain in the UK, has recently, in spite of doing what it thought it was doing right, and in spite of the judge saying, yes, you were doing everything pretty well, has been found to be vicariously liable for the theft of the data of 100,000 of its employees, which was then leaked onto the internet by a rogue employee, because that was carried out by that employee in the course of his other duties. And it's that, the thinking about what appropriate organizational measures might be, the how do you deal with both direct and vicarious liability, that should be part of your thinking about how do we deal with the requirements for data protection by design. One of the ways you can demonstrate you're complying with a law is through codes of conduct and certifications. I mentioned Cyber Essentials, which is a government minimum security assurance standard in the UK, applicable to organizations providing services to central government and to others. But there are also British standards like BS 10012, which deals with management of personal data, and ISO 27001, which is an international standard dealing with information security management. And the combination of those are practical ways in which organizations can demonstrate compliance. So we, IT Governance as a company, we have a Cyber Essentials Plus certificate, we have BS 10012 and ISO 27001 certification certificates in a combined management system, which enables us to demonstrate to stakeholders, customers, suppliers, and to board and shareholders that we take managing their personal data seriously. And if we have a breach, and we assume, like all organizations, that breaches are not inevitable, we'll be able to demonstrate that we did the best we could to deal with that. Certification does not absolve one of the need to comply with GDPR. The third area where you have major exposures is, of course, international transfers, and any transfer of personal data by a controller or processor can only take place if, in principle, the data is going to somewhere where it will be as safe as it was when it was collected. And that means if it's going outside of the European Union, it can only go to a country for which the European Commission has made a finding of adequacy. There isn't such a finding for the United States, for instance, but there is for Canada, there isn't for Australia. And there are appropriate safeguards in place to ensure that it's protected. One way of dealing with that is something called binding corporate rules. There are other structures which are available, but you need to talk to specialist data protection lawyers if you're looking to move data outside the European Union. It's a specialist and highly a sensitive area, and one in which you need to make sure you've got the most appropriate controls in place. Cloud providers are a risk, higher penalties, as I've said, in these areas. And if you're dealing with the United States, of course, there was the challenge of what was the safe harbor framework found to be wanting. So that was kicked into touch, replaced in July 2016 with the EU-US Privacy Shield, which is going to have its second review later on in November. We don't know whether it will be marked to continue. We assume it will do. But if you're taking data into the US, it can only go to organizations which are registered under the EU-US Privacy Shield. And that brings us all the way back around to the Information Commissioner. The GDPR requires member states to create supervisory authorities and resource them appropriately. Most member states already had some form of supervisory authority, or in the UK's case, that's the Information Commissioner. And the supervisory authority's tasks are to monitor and enforce the regulation, to communicate, promote awareness, but also to investigate, correct, advise, enforce, and levy monetary penalties. It's possible for supervisory authorities to take on a lead role for companies which are providing services across multiple states. And that means that you could have a supervisory authority in Ireland on account of the fact you're providing services through the whole of the European Union from your Irish business. And that means that you only have to deal with one supervisory authority. From a UK perspective, the requirement is that your supervisory authority for multi-state activity should be a European Union member state supervisory authority, and that potentially creates problems post GDPR. We don't yet know how that's likely to be resolved. The European Data Protection Board has the overall role of ensuring that there's proper cooperation and consistency between the supervisory authorities to ensure that that level playing field is genuinely in place, and that all of the many areas which are open to interpretation are interpreted in a way that does not create complications that are different in different member states. The ICO finally said, well, yes, GDPR means you have to spend some money, but that's a good thing to do. You can, if you're spending money on building proper privacy frameworks, get yourself into a very effective competitive position. That's a good thing to be doing. If you don't do that, yes, of course, we have a big stick. We've already proven that we're very happy to wield it. And just a reminder, bear in mind, we're not just going to deal with the minor stuff like you left an unencrypted laptop on a train, but we're going to be punishing in the context of accountability. If the organization has not carried out proper data protection impact assessments, doesn't have a data protection officer, hasn't got proper documentation in place, all of those will be taken into account to determine what an appropriate level of fine is. And that, again, was in that speech in January, nearly 18 months ago. So what should you be doing? Well, you need to be making sure you've obviously got a governance framework in place. You need to have a data protection officer or a senior data compliance person. Data protection officer tends to be the most practical way to go. Identify the data you've got, which processes you're dealing with. Make sure you dispose of any unlawfully held data. Carry out a proper data flow audit. Do a gap analysis to see where you're not compliant. Make sure that you've got appropriate privacy notices and subject access request documents in place. Process records properly. Do a DPIA and security gap analysis in regard to high volume processing and high volume systems, and then remediate. Do any fixes that you need to do to make sure you pull yourself up to an appropriate level of compliance. Put a privacy compliance framework in place. Start pursuing certifications like Cyber Essentials and ISO 27001. Test your data breach response process. You don't want to be trying to find out whether it works or not after you've had a breach. And then continually improve. Think of data protection as a journey, not a destination. If you're in the early stages of your program right now, that's fine. Just get on with it. And having got to the point where you say, yes, we've think we're compliant, don't stop. You need to be continuing to improve and embed data protection inside the organization. And there are a number of ways in which IT governance can help you do that. We're a one-stop shop for everything to do with GDPR, so from pocket guides and implementation manuals through to pre-written documentation templates, a gap assessment tool, which with a small amount of training you can learn to use yourself to identify where your gaps are in terms of GDPR compliance, all the way through to foundation, practitioner, and data protection impact assessment training courses, which can be done in a classroom or in a live online classroom, or in a workshop or through distance learning, and of course a substantial range of consultancy services that you can draw on. We can do a gap analysis for you. We can do a data flow audit for you. You can buy tools from us to do a data flow audit. We can teach you how to use them. We can help you implement PIMS and ISMS, do cyber health checks, pretty well anything that's appropriate for what you need. And many of our services are available for small and medium businesses on our website. You can read about them. It's very transparent. Pricing and delivery is all very clear. So there are lots of ways we can help you. You can draw on our ongoing series of GDPR compliance websites, visit our website, email us, or deal with us on any of our social media platforms. And that brings me to the end of what I was planning to say. So I'm going to stop now. I'll deal with any questions. And just a reminder on questions that if you do have any, the way to deal with them is to take the Q&A or the question box in the GoToWebinar panel. Click on it. You can type a question in there. I'll read out the questions and then I'll share with you the answers so everybody knows what they are. And the first question, there's a few that are the same, so the answer is the same for all of you. Is it possible to, or are we circulating a copy of the slides? Yes, if you are on the webinar, you'll get over the course of the next week or so a copy of the slides sent to you, so you'll be able to refer to them. If you are wanting to carry out your own data audit, where would you advise getting clear guidance criteria so you can make sure you meet the requirements of legislation? Well, if you want to carry out your own data audit, the first thing you need to do is make sure you have a proper understanding of GDPR. So you can get a good understanding of that by reading the GDPR manual or going on the data protection the GDPR practitioner training course. That'll give you a really good understanding of what's required. There are a number of areas where understanding GDPR requires a particular legal background, and part of the definition of the role of a DPO is that they have to have appropriate level of legal qualification and experience to be able to understand what words like lawful or legitimate might mean in context, because while you could come to the conclusion that you've observed the principles, you might still not be compliant compliant because you've misunderstood the extent to which legitimacy applies to your actions, or the extent to which your processing of personal data for direct mailing is in conflict with the requirements of the current e-privacy regulation, which creates some particular complications. So while you can, if you're not a lawyer, do a substantial amount of GDPR auditing, compliance auditing yourself, you do need to have legal expertise, and you can hire that on a per day basis from companies like GRCI Law, which is one of the group companies, and no doubt from others, which can give you the specific audits of those components of your management system as you require them. And unless there are any other questions, that looks to me like it's the end of our time together this afternoon. So I'd like to thank you all for joining us today. If we can help you at any other point, please do log on to any of other webinars. Otherwise, I wish you success with your GDPR compliance journey. And as I said, if we can help you, please do come on to www.itgovernance.co.uk and take advantage of any of the products and services that we can provide you with. Thank you.
If you want to, but I don't mind emailing the customer back if that makes sense.